And so I believe the next thing we're doing is we're going to turn the mic over to Leah Sandwell-Weiss, who is
Thank
going
you.
to talk to us about the eviction process. And this will go into not a whole lot of detail, but some detail about what happens if someone gets an eviction notice and what they have to do and how the courts are involved. So Leah, take it away.
All right. Thank you for being here today, and hopefully this will help for you and for folks that you know to help understand a little bit more about the eviction process. Now, I was a lawyer, but I never practiced in this area. I just did occasional research in it as a law librarian. One of the things that we always start off with is a little bit about what we're going to cover today. And and a distinction in what we're not covering today. The Arizona eviction law is very complicated. At least it seems so. And it covers a lot of different things. So today I'm going to cover the basic residential, you live in an apartment or a house and you're renting it, okay? Some folks, however, live in mobile homes or they live in RVs. They have different rules for them, but I'm not going to cover them. I'm also not going to get into the weeds about different types of defenses that you might have, counterclaims against the landlord, things like that. This is primarily just the basics. So I'm going to start with some basic terms, words that you're going to, and phrases that you're going to see if you're dealing with a possible eviction. The two types of eviction that you might come across: for non-payment of rent, which is what we're thinking of right now. But what we're also finding is if landlords might, if they can't kick you out for non-payment of rent, they might look for something else. Or again, some material breaches may already exist. And we'll talk about what those are and the little bit of differences between the two types. We'll talk about what your options are and the general process, and then where to get help. And we've also already heard some good stuff from Danny about how you can get some financial help. So the general process, I'm gonna just show you the steps, and the words in bold are pretty much the terms that I'm going to be talking about this morning. So the landlord provides you a notice about the lease or rental agreement that you haven't been following, or they think you haven't been following. This notice has to be in writing. If the landlord calls you up on the phone, if they email you, maybe, I don't know that that's going to be considered in writing. But pretty much if they just chat or they send somebody over to tell you, hey, we haven't gotten your check, that doesn't count, and that has other implications. This notice will give you some time limits to see if you can fix this issue. If it's not fixed, then the landlord can file a complaint with the court to evict you. You're issued a summons so that you can come to court and try and make your case that you shouldn't be evicted. There's going to be a hearing then with the judge about the complaint. The landlord or his attorney or other representative will be there. You should be there too, if at all possible. And there's reasons for that. Then the judge decides who should have possession of the property, who owes whom any money, and will issue a judgment. If the judge determines you're to be evicted, then the landlord will request a writ of restitution or a lockout order that will to remove you from the property and change the locks. So, violating the lease. Sometimes these violations are called a material breach or material non-compliance. Something is material when it is significant. Okay, so there's a lot of detailed information in your lease, and if you don't do something that's in there, or do, do something that violates that, that can be a material breach, and that can be a reason for being evicted. So the notice, again, it has to be in writing. There's several different types of notices. There's a 10-day notice, which is a general notice to fix a lease violation that is significant or material. Example may be your lease says the lease is for you and your spouse, and your brother comes and lives with you. He's not on the list of people who are allowed to be in there. That's could be a material violation of the lease. Or it says no pets and you've got your favorite dog with you. Okay. So you've got 10 days to try and fix those violations, kick your brother out, add him to the lease, get rid of the pet, add the pet to the lease, or you could then get a complaint against you. A 5-day notice, there are actually 2 types. The first one is again a material breach, but it's to fix any violation impacting health or safety. For example, you're a beginning hoarder. There's a lot of newspapers packed up on your porch, or you've got some kind of unsupervised pets that aren't allowed. Maybe you've got, I know my lease has a list of pets, of dogs that aren't allowed to have in the apartment. And so you get that pit bull or the Doberman or the whatever that could be a more serious violation. The other type of 5-day notice is you haven't paid your rent. Again, usually you have your lease, your rent is due on X day. You have maybe 5 days to pay it. You have 10 days to pay it with a penalty. And after that 10 days, you can be evicted. So the final type of notice is an immediate notice. This is very serious, a material and irreparable breach, meaning that it's something that they don't think you can fix. You've damaged the property. There's dangerous criminal activity that's happening, that sort of thing. The landlord then can immediately end the lease and kick you out very quickly. Now, one of the things is then they shouldn't mix and match these notices. You shouldn't be getting an immediate notice when it's for failure to pay the rent, for example. Now, a complaint, that's what the landlord believes you did to violate the lease. So there's some specific things that have to be in it, why they want you out, when you were served or given the notice, how you were served or given the required notice. And if you're getting subsidized housing, there's a technical requirement that needs to be in there too. Could make a difference in how much money you owe. Then you'll have a summons. That's the official notice of a lawsuit. Provides information about the complaint and details about the hearing, like when it's going to be and location. It's usually 3 to 6 days after the summons is issued. So notice that how quickly this can be happening. The landlord's responsible for serving you at least 2 days before the hearing. Now, when you're being served, it has to be delivered in person, either to you or to another person of suitable age and discretion who lives with you, your spouse or partner, not your 5-year-old. Or they can post a copy on your door or other place where you're likely to find it and send another copy to you by certified mail, return receipt requested. Then you'll have the hearing. Now the hearing is to decide if the landlord has a legal right to evict you. And if you believe they don't, you can respond to the landlord's complaint by providing an answer with the court. Now, the answer is a statement from you in response to the allegations made in the complaint. You can file a written answer or you can go to the hearing and answer in open court. Now, there's different options with this. The written answer is a good thing to do, but there is a fee. But on the other hand, you can file a fee waiver. If you just answer when you're there at the hearing, there's no fee. Now, this is where you would put your defenses, such as I did pay the rent, I got caught up, I didn't have the right notice, that sort of things. Now, why should I bother going to the eviction hearing? Well, it provides an opportunity to tell your side of the story to the judge. You have definitely a possibility of winning your case and staying in your home. If you don't show up, you have you basically have no chance. It's an opportunity for the judge to order landlord to make repairs or address serious conditions that are the landlord's responsibility. It's an opportunity to appeal the judgment. If you're not there, you can't appeal the decision. So then the judge is going to decide two things: whether you should be evicted, a judgment for possession, and a judgment for money, how much money you owe the landlord or the landlord owes you. Then there's what's called a writ of restitution. This is the court order instructing the sheriff or constable to physically remove you from the property and change the locks. There's some timing on this. If it's non-payment of rent or material breach, there'll be at least 5 days before a writ of restitution is issued. Again, this is quick. If it's material irreparable breach, you may only have a day or less before it's ordered. This is also called lockout orders. So now we'll go into a little bit of the options and process for the two different types of evictions that we're talking about. If you are being evicted for non-payment of rent, you've gotten notice, you have 3 basic options. You can move. Just surrender the possession within the time period set in the notice and leave. Now, why would you want to do that? Well, this should stop the eviction process and mean that you won't have an eviction showing up on your record. As you may know, it's very difficult to find another place to rent if you've been evicted and have that on your record. You can pay any part of the rent owed within the notice period and hope the landlord accepts it. So you borrow money, you get a good chunk of the money, you pay it, you take it to the landlord and said, will you take this as a good faith effort for me to pay this and stop the eviction? Document, get witnesses if you can, as well as a receipt. The landlord doesn't have to accept it, but if he does, this should stop the process. Or you could do nothing and wait to get the notice. So here's a flow chart that kind of shows all this. You leave the property and surrender possession within the 5 days of the notice period, then the landlord shouldn't be filing an eviction notice. If you pay any part of the rent and it's accepted by the landlord, again, no eviction should be filed. If you don't pay or move out, then the landlord will file the eviction action and you're served with the summons and complaint. Now, at this point, you come up with the money and you pay the landlord, then the eviction should be dismissed. But at this point, you're probably having to pay the full amount owed, and there's maybe some fees that you'll be required to pay too. So it's a bit more expensive, and it should be dismissed. But say you don't do that either, and it goes to a court hearing. You attend and you dispute that you owe all this money. There's a trial, and then the judge enters a judgment. You win, yay, you can stay. You lose, well, then there's a writ of restitution. It's executed and you are locked out of the property. There's some technical stuff about how much time you have to get your stuff out, and also how long the landlord can keep your property before disposing of it in whatever way they choose. It's usually 2 weeks. Now, if you don't go to the hearing, you get a default judgment against you. These same results apply. If you attend, but you admit that, yes, you owe this, then the landlord gets a judgment in his or her favor, and these same things apply. What if I can't pay the rent because of COVID? Now, this is what Danny was talking about earlier. Filling out the CDC moratorium form, give it to your landlord. This should put him on notice that this is what's going on. If you're still given notice of eviction for non-payment, attend the hearing and provide all your documentation to the judge. This should stop the process for now. But remember, it's not, it doesn't eliminate the need to pay the rent. It just delays the eviction. Now, if it's an eviction for material breach, the notice has to give you this, again, the specific information, what's wrong, how much time to fix it, 5 or 10 days, and how the landlord's going to file for eviction. And your options are similar. You can fix the problem within the 5 or 10 days, or you can move out within 5 or 10 days. And the chart is similar in a way as well. You go to a court hearing, you attend it, you dispute it, you say you fixed it, or it really wasn't that much, it doesn't fit the qualifications of being a material breach. The judge decides. You win, yeah, you can stay. You lose, there's a writ of restitution, a lockout order issued with that is executed, and again, they can hold your property for 14 days and then get rid of it if you can't get your stuff out. If you don't attend the hearing, default judgment against you. You attend the hearing, but you admit it that there was this breach, but it's just not fair, whatever your defense may be, the judgment is ordered for the landlord, and the writ of restitutions go on, and you're forced out of your apartment or home. So what can you do? Seek help as soon as you know you have a problem. When you see that you're going to have problem making rent, apply for rental assistance and contact these agencies that can give you some legal assistance. The sooner you can get some help, the better. So there's a website, Arizona Eviction Help, at let's see if I can bring this up, that goes through all these steps, has links to a lot of stuff, helps you with your rights, and also has help is available. They have links to this information. The Step Up to Justice, where Amanda works, has attorneys, both within the organization and contacts of folks that volunteer attorneys. You can apply for help through them, or you can sign up for their eviction prevention legal clinic. And I'm sure Amanda will be talking more about that after our breakout sessions. Southern Arizona Legal Aid provides us eviction help. That's their number. And of course, for rental assistance, here's the link that Danny had. So that's the end of this presentation. I think we're ready to move on to our breakout rooms.